Are non-competes illegal in the US yet? I'll give you the latest as of August 13th with three notable updates. And if you're pressed for time, I get it. The non-compete ban in the US by the FTC, Federal Trade Commission, is scheduled to take effect September 4th. But there are legal challenges. And in part, August 30th is the date that a judge in Texas that has already partially halted the ban for a very small group of employers, has said that she will issue a decision by August 30th. And people are expecting that that could lead to a nationwide strike of the ban so that non-competes could still happen. So August 30th is a key date to watch, but I'll tell you why it could be sooner. So in short, that Texas case, so that's by Ryan LLC, a global tax advisory firm, and a bunch of other groups like the Chamber of Commerce, Business Roundtable. They've all joined onto that. So that's a huge number of business groups saying, hey, the FTC, you don't have legal authority to issue this ban. That can only be done by Congress, elected officials. The FTC is appointed as part of the executive branch, so you don't have the authority. So that's the legal challenge, and that's where the court already, Judge Ada Brown, had halted the ban from taking effect for a small group of employers like Ryan LLC and like the Business Roundtable, Chamber of Commerce as employers themselves, not like their member companies. And so that's why, looking at her logic and her order, a lot of people watching this, and I'm a lawyer, certainly not legal advice, but just some updates, that a lot of people do expect that she could issue a nationwide ban on August 30th, the date that she's said that she'll give an order. But what happens now are these amicus curiae, which are called friends of the court, different groups that are filing briefs that basically say, like, long legal documents, like, I agree or I disagree, I'm with this side. And so all these different groups are filing them. And so one notable was Langone Health. So a broader group, I can't remember the name, but it's about medical, like hospitals. They had filed a brief in favor of the business groups saying, hey, we should strike down the ban because we need non-competes and we need those in the medical profession. Well, Langone Health is out of New York City, and they actually filed their own amicus curiae brief that said, hey, because we feel so differently from this hospital group, we want to file our own. And to me, it was really interesting because I've always had this kind of issue with like medical care and non-competes, and it can make it really hard for patient care. And if you are a patient or a family member and all of a sudden your doctor is hamstrung to one practice because they can't leave due to a non-compete, like, it can be a really challenging situation, to say the least. So Langone Health, they wrote a brief and they said, hey, we are like the #1 ranked, and they cited the ranking, ranked in this region or whatever, all these things. We've done all of these things to create a great environment. And we do not have non-competes, and we don't need them. And we see them because we try to hire people, and their non-competes will say, like, you can't, go work at our Langone Health. I hope I'm pronouncing that right. But that is a hospital that has said, we do not have non-competes, and we run an incredible operation, and we're able to do it. So we are in favor of the FTC's rule banning non-competes. And so it's interesting. So if you are someone that's not in favor of non-competes, the Langone Health amicus curiae was really interesting, talking about how they create an environment where people come and want to stay and work there, medical and other professionals. And they say, we do not have non-competes. So that was one kind of, especially in that healthcare setting. So that was amicus curiae briefs filed there. Another was filed yesterday by SHRM, the Society of Human Resources Management. And in that, SHRM has said, like, they're like, hey, we won't say everything we feel about non-competes, but they spend like a page saying non-competes can be appropriate when tailored to protect confidential information, training, investment. So SHRM represents, whole thousands and thousands of human resources professionals. And I found this interesting because, having worked in legal and HR, most people I know in legal and HR do not like non-competes because it makes, can be incredibly confusing, unpleasant, to say the least. Because when you're hiring someone, like if you're in recruiting, you get them the offer, you're all excited, then they look through and they're like, wait, what's this non-compete? What does this mean? Where can I work? Where can I? And a recruiter may say, like, oh, I can't give you legal advice. I don't know what to say. The candidate doesn't understand it. And so it creates like that great offer, like offer time, here's the offer, can make it unpleasant. Likewise, when people leave, someone leaves and maybe they don't realize they didn't sign a non-compete, or they're like, whatever, I'm just going to go work elsewhere. And all of a sudden someone comes to like HR or legal, and it's like, you got to stop them. HR's like, I don't, why would I want to go tell someone they can't make a living? Like, So in my experience, people in legal and HR often don't like non-competes. And so if you are in HR, I'm just curious your thoughts on those, because SHRM, put forth this brief seeking to have the ban struck down so that organizations can continue to have non-competes. The last is there is one other lawsuit that I had not seen yet that was filed in June by the Villages, which is a retirement community in Florida. I believe maybe the nation's largest, well, certainly one of the largest. I know it because my parents retired there this year, but it's by Properties of the Villages, which is the real estate group. And so they filed their own challenge to the FTC's rule banning non-competes in a Florida federal court. So you have this Texas case. You also have a Pennsylvania case I've talked about where the judge there, it had been brought by a small tree company. The judge there had struck down that challenge for now. So that case is still going forward. But the judge there was like, we're not going to halt the non-compete ban. That's by ATS Tree Services. But Florida, there is a case that was filed by the Villages about their real estate teams. And so in that case, there is an update. There's a hearing in federal court tomorrow, August 14th. And I don't think the judge there has done what the judge in Texas did and said, hey, the date that they'll give their decision by. But that hearing's tomorrow, August 14th. And the non-compete ban is supposed to take effect September 4th. So what to watch are by August 30th, you're going to see which could be a strike down on the ban. You have this case in Pennsylvania and now potentially a decision in Florida. So all of this means like a circuit split. So the Court of Appeals may have to hear some of these decisions and like, okay, what applies if we have different decisions in different courts? And that goes up to the Supreme Court. But August 30th is still the day to watch. But keep your eye on Florida for this case by the Villages challenging the FTC's rule because we will have to see what happens there. But like a lot of rules these days, there's challenges in court, and it's hard to predict exactly what's going to happen. But it is notable because organizations on September 4th, when that ban takes effect, organizations then will have an obligation to notify their employees that there is no non-compete anymore if that non-compete ban takes effect. So that's why a lot of departments are watching, not just because they'll know whether they have them or not, but then they'll have to send out notices. So we will see if that all gets upheld or struck down.